So when it comes to employment law, I think the sort of really important starting point is to realise that even though, as Hugh has said, algorithms can in some sense today take the role of the traditional boss, the chap with the bowler hat, in reality, even though the technology is new, a lot of the underlying challenges from the perspective of employment law at least are actually ones we've been seeing for a long time. And so the key challenge, I think, the first one we need to tackle and think about today is this vexed question as to the scope of employment law. And in any employment law course I'm aware of, pretty much, that's the very first week of what you do. And the question of scope essentially means who gets to fall within the protected norms of employment law. Who's an employee, who's a worker, and also more recently, who's an employer. Now, Anne will say a lot of this in great detail later on when she talks about the details of the current legal setup. But essentially, the real challenge we see with self-employment at the moment is that, as opposed to the historical approach, where we simply had a binary divide, either you were an employee and you got all the benefits of employment law, you were right within the scope, or you were an independent contractor and completely outside it. What we have today, in English law at least, is a tripartite divide. We have this intermediate category, the worker, which has been in extensive use since the late 1990s in particular, which gives rise to some really interesting questions as to what sort of tests do we use to divide between these categories, and also more recently, what is the actual relationship between these different categories. Also, with self-employment and with this rise of the fragmentation or fissurization of the workplace, the second question that crops up is as to identifying who the responsible employer is. You think of certain platforms like Amazon Mechanical Turk, or you think of just any old traditional labour outsourcing agency. There's really difficult questions as to, even if the worker is entitled to protection, who should actually then bear the responsibilities attached to that. The second question, and one that again is not new as such, but has become, just because of the sheer rise Abi has shown, a much more pressing issue, are different potential avenues of avoiding the scope of employment law. So while some people will generally be independent contractors and fall outside it, in other scenarios you might see different legal strategies being used to recharacterize workers to fall outside the scope of employment law. And there's two main groups of strategies. There's sort of infinite varieties of doing it, but there's two main strategies. One is to go down the contractual route, to simply say we're going to insert the term in our contract of employment where we agree that actually this is a contract of for services, this is an independent contractor relationship. And actually from a legal perspective, with apologies to all the people in this room who spent litigating this on both sides, actually from a legal perspective, that's not a particularly difficult conceptual issue. Judges have long been trained to look at the reality of the facts on the ground and then juxtapose them with the contractual terms. The much bigger legal challenge is incorporation. This idea that actually rather than going down the contractual route, you go down the route of asking each worker to incorporate her own business and then to provide the services, as it were, on a B2B relationship between the employer business and the worker's limited liability company. And there, we then run up not against contractual doctrines, but we run up against corporate law, against the corporate veil, this idea that actually the corporate entity is to be treated entirely differently from the individual standing behind it. And that at the moment is actually the much bigger challenge for employment law, because we've seen cases even in the senior courts of, say, outright explicit sex discrimination, but it's done through a corporate structure, and therefore actually it's very, very hard for the legal system to grapple with it. So those are the two key challenges about the question of scope that self-employment gives rise to. And I think in terms of the focus today, those are the main issues we want to think about. Just very briefly, I want to have a flag up another set of issues, which in thinking about scope, we should continue to be mindful of. And there's two issues that sort of go beyond the scope debate that are particularly important, I think, from the employment law regulatory perspective. First of all, what happens once you are an employee or once you are a worker? What are the sort of standards and substantive norms you get? Because increasingly, I think, we're starting to realise that a lot of our existing standards of employment law are designed for long-term, stable employment relationships. So I think it's really important that by just focusing on the scope question today, we don't forget the fact that there's another big important cluster of questions out there, how we can rethink employment law standards so that they work in a world of intermittent work. And finally, and in a sense related to that, that's a question of enforcement. In one sense, the fact that we haven't heard yet about what's going to happen with the Supreme Court challenge to tribunal fees makes it difficult to talk about this. But at the moment, one of the really big issues is that you could legislate and give workers all sorts of rights today. In reality, it would change very little as long as there are no credible, meaningful ways of enforcing those claims.